Welcome to the Landmarks Chambers webinar, What Next? Residential Property Law in 2021-22. A snappy title that I'm sure enticed many of you to come in. My notes say that I am delighted to see so many of you joining the session today. Of course, I can't actually see any of you. I am, of course, though, delighted to know that you've all made it through the trials and tribulations of the last 14 months or so, and look forward to seeing some of you in person in the not too distant future. Even if, as I suspect, we end up doing more of these as hybrid sessions with some in person and some broadcast in the future. We hope you find this useful and informative as to what's coming up in residential property development over the next year, 18 months or so. For those of you who don't know me, my name is Justin Bates. I'm a barrister here at Landmark, and I am at least notionally in charge today. And I'll be joined by my colleagues Rupert and Kim, who I'll introduce in a minute. In terms of housekeeping, before we start, your microphones are all automatically muted, so you don't need to adjust any settings on your computers. We are very keen to have questions as we go along, primarily because we want this to be of use to people and we want to talk about things that you find interesting and useful. So please do put questions in, but we'll probably try and pick them up at the end of the session. This webinar is recorded, so you will receive a link to the presentation in due course, so you can watch it again on our YouTube channel to your heart's delight. Amazingly, at least to me, it turns out there are people who go on our YouTube channel and watch our old videos all about presentations, all about law. So apparently you can go and do that as well. If you lose your connection at any point during the webinar, then the way to join is just click on the original link once again, and you'll come back in. So let's begin. In terms of the topics for today, you've got first of all, you're going to hear from Kim talking about the Law Commission reforms of the enfranchisement proposals, the right to manage proposals, and the common hold proposals. There's a little bit of I suppose, high levelness to all three of these talks, but particularly to Kim's, because of course there's a lot in those proposals, and there's a limit to what you can do in 15 minutes. Rupert is then going to pick up on the leasehold related reforms that aren't Law Commission proposals, so the government's proposed changes to ground rent in particular, and also touch upon the proposals as regards estate rent charges and estate management fees. And then for those of you prepared to hang around to the end, you've got me talking about the Renting Homes Wales Act, which is not only of relevance for people in Wales, albeit I accept it's mainly of relevance for people in Wales, but I think is absolutely fascinating as an indication as to what the future of residential housing law might look like in both England and Wales, as England does tend to follow Welsh developments a few years later. And I can see England being interested in watching how this all pans out. Questions at the end. We're all going to speak for about 15 minutes or so. There's a slight frustration to today, for which I am sorry. But as it turns out, at least the things that Kim and Rupert are talking about, they might also be being talked about by the Queen at the moment, because the Queen's speech has just started, and we are expecting announcements about the Law Commission reforms and the wider leasehold reform agenda as part of this Queen's speech. So I will keep one eye on the Queen's speech during this talk, and if there is any announcement there, we'll try and pick it up in questions at the end. That's probably as much as I can usefully do for an introduction. So I'm going to be quiet, turn my camera off, and hand over to Kim.
Good morning. Thanks, Justin. As Justin said, I'm going to be talking about the Law Commission residential leasehold reforms. This is a subject that's relatively close to my heart because I was working at the Law Commission back in 2017 when this all kicked off. And as Justin already warned you, I'm trying to cover three pretty chunky reports in the space of 15 minutes. So it's going to be a bit of a highlights reel of some of the key reforms. I thought I'd just start, it'd be helpful to just start by having a quick look at an extract from the terms of reference for these projects. For those of you who don't know, the way that the Law Commission tends to work with projects like this that's being asked to carry out by a government department is to agree terms of reference with government as to what exactly is going to be included within those reforms. And for this particular project, as you can see there, it was agreed that they're going to be looking in the first instance on reforms to enfranchisement, common hold and the right to manage. But there might be further areas brought in at a later date. But I thought what was particularly interesting is the point that I've put at the end of the slide here, that this is an area where government was quite strict or quite directive to the Law Commission as to what these proposals or what the reforms had to achieve. and including to provide a better deal for leaseholders as consumers. So as we go through, you'll see that a lot of these reforms are all about making things better for leaseholders, as opposed to necessarily making things better for landlords. Hopefully some of them will make things better for landlords as well, because of just simplifying the procedures. But that was the lens through which the Law Commission was asked to consider these areas of law. And I think that's worth bearing in mind when we go through what the actual proposals are. So moving on quickly, just a quick overview of where we're up to. The Law Commission has consulted on all three of these areas. It's produced 3 large consultation papers with provisional proposals. It's then had an analysis, it will have received responses from the public, analysed those, and produced its final proposals in 3 reports. In fact, there's actually 4 reports, because there's a separate options report on valuation that was provided to government a little bit ahead of the other reports that were published in July last year. We had a response from the government on some things in January this year in a statement by the Secretary of State, but not on everything, and I'll turn to that right at the end of my talk. And so far we've not had any legislation brought forwards, but as Justin said, we're expecting to hear at least some of the proposals potentially being brought forward in a bill in this session, which will be announced at the Queen's speech, and potentially further reforms for later sessions in this Parliament. So let's see what happens during the course of this, and Justin might be sending me an update at any point saying what is going on there. So turning on to the first topic then, which is enfranchisement. So the Commission's looked at various aspects of enfranchisement legislation, but effectively the idea was, if you were starting from scratch and trying to create the rights that the Leasehold Reform Act 1967 and the Leasehold Reform and Urban Development Act 1993 acts were providing, we wouldn't create the system that they have provided. It's an extremely archaic, it's complex, you have to piece together legislation from all sorts of different amending statutes, and it's often very, very difficult and a real trap for the unwary. So how do we take the bits that we like and the bits that we think are important rights, and how do you reconstrue that in a new system that is much easier for everybody to use? And so it's sort of looking at it all again from scratch. And what they've come up with are that there should be a right for a 990-year lease extension for houses and flats. So we're no longer going to have this distinction of legal regimes between, one regime for houses and one regime for flats. We're to try and come up with one regime for both. Leaseholders should be entitled to buy out their ground rent under an existing lease without extending their lease term. So this is all part of government's push to help leaseholders with onerous ground rent clauses. Third, there should be a right to extend the term without buying out onerous ground rents if leaseholders would prefer to do that, rather than buying out the ground rent, or they can't afford to buy out the ground rent. And then there'll be an individual and collective freehold acquisition right. So that's effectively your enfranchisement rights in terms of acquiring the freehold for your house, or collectively enfranchising in terms of blocks of flats. And as you'll see, there's this push towards simplified language and language that people can understand. So freehold acquisition rather than enfranchisement or lease extension language. Again, points to note, and as I said, this can't be comprehensive of every reform, so there'll be some proposals that I'm not covering, but some interesting ones I think are that the Law Commission is proposing that multiple blocks should be able to be enfranchised in a single claim. And also they're proposing a requirement for the landlord to take leasebacks of non-participating units to help leaseholders where maybe not where a sufficient majority, but not everyone is participating, to be able to afford the enfranchisement claim. So then they looked as well at the qualifying criteria for enfranchisement. And again, as I said, because this was a sort of go back to a drawing board exercise, they wanted to create a new unified scheme for qualifying criteria, and with the aim of making more leaseholders eligible. And they're quite clear that that is their aim in looking at the qualifying criteria. So that includes things such as making buildings where up to 50% of the building is non-residential eligible for qualifying for enfranchisement, which is higher than it is currently, abolishing the 2-year ownership requirement that currently exists, abolishing the low rent tests and rateable value tests, which I'm sure will be music to the ears of anyone who's had to look at those, delve into the depths of those, as they're quite difficult to understand and apply sometimes. And this is all starting with this basis of a residential unit, rather than looking at, is it a house, is it a flat, and all of the complex case law that goes along with that. There's going to be a definition of what is a residential unit, and that is the starting point for whether or not these rights will apply to you. They've tried to put this all together in a nice flow chart, and I'd recommend having a look at it. It's at figure 6. You've got the reference there to the report. And that's sort of the questions that you would have to go through to decide which of these rights applies to you. They've also recommended that live-work units should be included, because there's a question mark over whether those fell under the exclusion for business premises that currently exist. Shared ownership leaseholders are to be given a right to lease extensions only. And there's going to be a new exemption. This is the only place where there's a limitation being imposed on what currently exists for community-led housing development. So leaseholders within those types of development will not be able to enfranchise or exercise any of the new rights. So looking then at procedure for enfranchisement, again, it's all about providing a new single procedure for all claims, regardless of whether it's a house or a flat, or and it's particularly for freehold acquisition claims. As we're used to now, there'll be prescribed claim and response notices, hopefully brought a bit more up to date and made a bit more straightforward to use. What I think is quite an important proposal is this prescription of categories of addresses and then deemed services if you are serving the notice at one of those prescribed addresses, to try and avoid this problem that we currently have of lots of disputes over was the notice properly served and received, and when can you then apply to the tribunal on the basis that no response notice has been received. Competent landlord is going to be responsible for serving on any intermediate landlords, so the tenants don't have to worry about trying to figure out who those are. And they're trying to really limit the validity of challenges to validity of notices, because that's where a lot of disputes occur in relation to enfranchisement litigation, and can be quite costly and off-putting for tenants. As we have now, if there's no response from the landlord within time, leaseholders can apply to the first-tier tribunal to have the claim determined. However, they won't have the windfall of the claim having to be determined based on the claim notice. So that's actually one place where things for leaseholders are being made a little bit less beneficial than they perhaps are currently. I won't go through all of these because I'm conscious of the time, but you've got a good summary there, hopefully on the screen. In terms of dispute resolution and costs, and this is something that is a theme across all 3 of the reports, there's a big push towards there no longer being a split jurisdiction between the county court and the first-tier tribunal. So for enfranchisement, it's going to be first-tier tribunal only. So there'll be powers for the first-tier tribunal to enforce a determination that's made or any agreement between the parties, to execute a lease extension or transfer, and to access the court funds office to allow the taking of receipt of funds where that's necessary. So effectively replicating the powers that currently require claims to be sent off to the county court to deal with some of these points. And there's also a proposal which I think is quite sensible about having certain valuation only disputes being heard by a single valuer rather than having to go to a full tribunal hearing. There's also controls being imposed on leaseholders' liability to pay non-litigation costs of a landlord, because that can be quite a contentious area. There's a proposal for an enfranchisement restraint order where several invalid claims have been made by the same leaseholders, and also a push for standard tribunal costs rules to apply, and anti-avoidance measures in terms of clauses in leases that might provide that leaseholders have to pay landlords' costs, just to try and again make it much clearer for leaseholders how much this is going to cost, and not off-putting people on the basis of this getting out of hand. Finally then, in terms of enfranchisement, there was a separate valuation options paper that was published earlier last year. Again, options to reduce the price payable. That was very much the only way that the government was going to accept. The government wasn't going to accept any recommendations that would put the price up. And the Law Commission proposed 3 schemes, essentially, for valuation. One where the leaseholder is treated as never being in the market, so you only value the term and the reversion. Scheme 2, where the leaseholder isn't in the market at the time of valuation but may be in the future, so you take into account some hope value in certain circumstances. Scheme 3 is where the leaseholder is in the market, so basically what we have now for most enfranchisement claims, where it's term plus reversion plus marriage value where that applies. And then within that, there were various sub-options that were recommended that the government could introduce if they wanted to bring costs down further or give further certainty. For example, prescribing rates and capping the treatment of ground rent and various other things. But another big push was for this online calculator system, which would help leaseholders to be able to predict in advance and get a better understanding of how this valuation was going to work without having to get expensive and complex valuation evidence straight away. So that was enfranchisement in a nutshell. As you may tell later on, enfranchisement was the bit that I worked on primarily, so that's the bit I'm perhaps most interested in. But I'm going to go through right to manage and common hold as quickly as I can within the time allowed. Right to manage, again, one of the main proposals here is introduction of right to manage for leasehold houses, and again using the same process as exists for flats, about the theme of looking at a residential unit rather than treating flats and houses very separately. There's going to be a codification of case law on the meaning of a building. Again, there's increase of a non-residential limit within a building that will allow the right to manage to be exercised more widely. Shared ownership leases over 21 years can be included now in a right to manage claim, even if they've not been staircased to 100%. They want to abolish the residential landlord exclusion, allow for a single claim by a single RTM company of multiple buildings, and get rid of the prohibition on using RTM companies as nominee purchasers for collective freehold acquisitions, so for collective enfranchisement claims. There's also going to be, one of the recommendations is about not having more than one RTM company existing in relation to, so they are going to allow more than one RTM company to exist in relation to each set of premises. And then things around training requirements and resources to help RTM companies do the best job that they can and to be more effective, together with changes to simplify and clarify the acquisition process. Now, I should just note that there's a Supreme Court case that Simon Allison and myself are involved in that's being heard in November that might have some effect on the basis for the management powers reforms that are being proposed by the Law Commission. So that's one to sort of watch this space. It may be, as this Justin has predicted, that the Supreme Court tells us that we're premature and they don't want to hear our appeal on the basis that the Law Commission might change. The Law Commission recommendations will deal with all of these issues. But there's a watch this space on that particular point. Other reforms that are being proposed here: greater rights to obtain information, strengthen notice requirements in relation to management contracts. These are the reforms to the management functions, as I'm saying, that might be affected by that Supreme Court decision. Clear division of responsibility between RTM companies and landlords. Again, costs similar to the enfranchisement regime. They want no non-litigation costs being paid for by leaseholders, usual tribunal cost rules applying, anti-avoidance mechanisms, more jurisdiction for the FTT to determine points here rather than having that split jurisdiction, and then clarification of the procedure for and consequences of terminating the right to manage, which can be quite complicated at the moment. So moving on then to common hold, again, just a bit of a highlights reel here. The whole aim of these reforms is really to ultimately make common hold a preferable alternative to leasehold ownership. So that includes both facilitating conversion from existing leasehold properties to common hold, but also reforms that will help new common hold developments come forward onto the market and incentivize developers to build things and have their developments as common hold. So those include reforms to the current common hold community statement that's required, enabling shared ownership leases to be granted within common hold, providing a more robust regime for financing and managing the common hold, including compulsory reserve funds, which is quite an interesting contrast to what currently exists with leasehold, and provision for responding to emergencies, for example, the ability to sell off common parts. And this is all really targeted at stopping the common hold company from becoming, the common hold association from becoming insolvent, because that's one of the biggest worries for lenders and people with the current regime as to what happens when that insolvency event arises. In terms of dispute resolution, again, this push to transfer jurisdiction to the FTT, but also future-proofing, given that this is something that is looking at a much longer-term reform to account for government's potential plans for a new homes ombudsman or a combined housing court, and then a reinforced role for ADR as alternative dispute resolution as well through the common hold regime. Again, one of the concerns around common hold at the moment is that it's sort of it's majority rule, and there's a worry that given so many decisions are made by a majority of the common hold participants, how do you protect those that are in the minority? And there's this introduction of a new right to go to the FTT to challenge some of those decisions in certain circumstances that it's hoped will give people more confidence in that system. Further, there's going to be a power for the Common Hold Association to apply to the court for sale of defaulting owner's unit. Again, part of this strengthening of the financial circumstances of a Common Hold Association. So if someone's not contributing to shared costs, then there'll be this ability to take them to court over that. Protections against striking off insolvency of Common Hold Association. Again, that main policy driver that's feeding through again. And then finally, reforms around voluntary termination of the Common Hold Association, greater power for the first tier tribunal to protect the minority who don't consent to that termination, right for lenders to apply to the first tier tribunal to protect their interests. Lenders obviously, buy-in from lenders is such an important part of this reform. And then provision for termination of part of common hold, if not all of the leaseholders obviously want, the common hold owners want that to happen. That was a real race through the reforms themselves in terms of the response that there has been from government. As I said, on the 11th of January this year, we had a statement from the Secretary of State announcing that there's going to be two-part legislation, one about future ground rents, which Rupert is going to talk about, and the second, effectively, the rest of the Law Commission reforms. But what they've said is that they're accepting a lot of the enfranchisement proposals made by the Law Commission, so including on valuation, abolishing marriage value, capping the treatment of ground rents at 0.1% freehold value. I won't read all of those out, but you've got them there. So that's their view on valuation. But they're also very happy with this new 990-year lease extension for houses and flats with redevelopment break rights, and the right to buy out ground rent that has been proposed. In terms of the common hold reforms, they've proposed this new common hold council that's going to help them developing those reforms further, and TBC effectively on the response to the remaining reports, so we don't know when that's going to happen. We know that the future ground rents legislation is supposed to be coming forwards in this session. Again, we'll see if that's in the Queen's speech. It's unclear exactly when the rest of the legislation will be, but again, we should have answers to that by lunchtime today. Right, that was a bit of a race through, but hopefully that was helpful, and I will pass on to Rupert now, who's going to talk about some of the government reforms on this point.
Hello, everybody. For the next 10 to 15 minutes, I am going to be talking about the specific anticipated reforms on ground rent and estate rent charges. So far as ground rent is concerned, I think it's helpful to place oneself in the shoes of the enfranchisement history when we're looking at the reforms which are anticipated. Leasehold Reform Act was passed in 1967 specifically because it was dealing with a lot of Victorian houses whose fixed term were coming to an end. And as it originally was promulgated, it applied to houses, but specifically houses with a low rateable value held on long lease at a low rent, and provided that the tenant could buy the freehold or obtain a 50-year lease extension at a price that was payable as originally enacted, based purely on the value of the land rather than the building. Many amendments have been passed since its original institution, so it obviously now applies to high value houses. The residence criteria has been relaxed, and most importantly, the price mechanism has been changed such that the method of valuation includes the building upon which the land resides rather than just the land per se. And that introduced the concept of not just marriage value, but very high value marriage value for very valuable houses. And that, of course, has been allied with the Leasehold Reform Housing and Urban Development Act 93, which again, I know you're all going to be familiar with, but that provided new rights to lessees of flats. And that's the right to collect for enfranchisement and the right to a new lease for an additional 90 years. And again, a little bit like the 1967 Act, it originally had residence requirements and low rent tests, but much of those have been muted as a consequence of changes, I think, in 2002. And when you're thinking about the valuation process, If you as a leaseholder want to enfranchise, you have to ask yourself when you're trying to ascertain the cost of that, what it is that the freeholder's got to sell. And ultimately what the freeholder has is a property subject to a lease, and the way that that's made manifest in terms of value is a ground rent for the duration of the lease, and then the value of the reversion. So the way in which the mechanism works in practice is that you capitalise that ground rent over the term. So in other words, you ask yourself what the capital sum paid today would compensate you, the freeholder, for the right to have the ground rent for the remaining term of the lease. You then have to ascertain the value of the reversion. And that's done by taking the freehold vacant possession value and discounting it over a term, because of course you don't actually realise that value until the term of the lease has expired. And you apply a deferment rate to enable you to ascertain that figure, which has been the subject of much controversy, as I'm sure most of you were. And then after that, you have the marriage value. And the reason why you have the marriage value is because the aggregate of the capitalisation of the lease rent over the term plus the freehold vacant possession rate, when the deferment rate is applied, because ultimately you're not going to realise that value in the future, falls some way short of the actual freehold vacant possession value. And the difference between the two, in other words, the cost of buying out the lease and the cost of the freehold as it will be coming forward, is the marriage value. And the way that the Law Commission put it in their reports, which is, I think, a helpful way of understanding really what marriage value represents, is if you imagine there is a pair of vases that come as a pair and are identical, the cost that you, if you owned one, would be prepared to pay is greater than that someone who didn't own one would be prepared to pay. So you end up with this tripod of mechanisms that end up to ultimately enable you to ascertain value. And there are various mechanisms that the government is considering, and we are anticipating some today, to actually deal with how ground rent applies within that wider context of ascertaining what it's going to cost to either extend your lease or to buy the freehold. Now, against that background, we have to approach ground rents. Now, the reason why ground rents have become such a ready topic, apart from the fact that the cynics amongst us might suggest it's just because it's a very easy thing to please the electorate, is because builders, when constructing new homes, could effectively sell it twice. And what they do is they build a home and then they'd grant a lease for a long period, and that would be the first point of sale. And as part of that lease, they would reserve the ground rent moving forward. And then, having granted leases of the entirety of the estate, they would then sell the freehold to a ground rent investor. Now, so far as ground rent investors are concerned, ground rents are a great source of income. Lots of pension funds have got interest in them and the like, and they would buy the freehold. And the reason why the ground rents are a great source of income is many of them are RPI indexed, or indeed, as I'll go on to explain, even more severe so far as the pecuniary consequences are concerned. But also there is very little risk of non-payment. I mean, fundamentally, if forfeiture is the consequence of not paying your ground rent, you're going to pay your ground rent. So ground rent investors were the second source of sale for developers. Now, so far as developers were concerned, you could get so much more from your ground rent investor if you had within those leases terms which meant the ground rent increased. I mean, the more dramatic it would increase, the more appealing it is for a ground rent investor, and therefore the greater sum you're going to get upon the sale of the freehold. But of course, there was a balance there. What the builders couldn't do was have high ground rents from the off, or ground rents that increased too dramatically from the off, because then you'd be putting off leaseholders who are buying the leases in turn. So what you needed was to find a mechanism where the short-term purchaser, so someone who's buying a lease, but it's not like it's going to be a property that's going to use, you know, if we're under the settled down like entailed for life, it's just a lease and you can buy and sell as you wish, but one that had ground rents that would increase dramatically over the time. And that's when you introduced what builders did, and the prospect of a ground rent starting small, but then, for example, doubling every 10 years, which would eventually rise to a very, very large figure when you bear in mind the term of the lease to which the ground rent is part and parcel of. Now, the difficulties that ensued when these leases were kind of made manifest, and particularly when various newspapers started making hay out of it, and quite properly so, is because the higher the ground rent, not just at a given point in time, but also prospectively, the difficulty it is to sell, more difficult to sell, and in some cases it becomes very difficult to mortgage, because mortgage companies, brokers have got their own internal risk mechanism, and one of the component parts of that is to what extent, or rather what proportion of the freehold vacant possession is the ground rent, because the higher the ground rent, the greater likelihood it is that the lessee can't pay, and then the greater risk that your mortgage is, or that you might have to step in if forfeiture proceedings are started. So that was what took place so far as lessees were concerned. It meant that they couldn't sell and they couldn't mortgage. But it also had another effect, which is the valuation effect, which is why I mentioned the kind of three component parts of the valuation process, because one of the constituent limbs is when you capitalise the ground rent, and that's the ground rent over the term of the lease, and then you have a discount rate to take into account that you're looking at the present value of future sums. And it meant that lessees were astonished to find that even though the ground rent was low at a given point in time, the cost of acquiring the freehold was very much higher than previously thought. And it's those twin purposes that brought this issue really to the public forum. I'm hoping I'm moving on to the next screen, so you'll just have to bear with me. So what are the proposals? What are we dealing with? Well, as Kim mentioned, there's a two-step change. I mean, to contextualize this, the proposals are, I mean, really very thin. We're expecting something today. But what we're actually expecting today is going to be the first in a small step of a kind of much larger process. The first step is that in prospective leases, in other words, those who have been granted, the ground rent is going to be zero. So you're expecting to abolish ground rents for prospective leases. And inevitably, you're going to have a raft of questions that come with that. You know, at what point does it take effect? What happens if you exchange before the institution of the legislation is complete afterwards? But going forward, ground rents for future leases are expected to be set as zero. And the next is a series of valuation changes. And so far as those valuation changes are concerned, I mean, in January, Robert Jenrick came out with a kind of commitment that the government will abolish marriage value. Actually, what that means is if you think of the previous regime, or rather the current regime, I should say, for dealing with marriage value, what you end up doing is actually dividing it 50-50. And that marriage value is, again, the difference between the freehold vacant possession value and the aggregate of the capitalisation of the ground rents moving forward, and then the deferment rate when you apply it to the freehold vacant possession value. At the moment, it's kind of conventionally split 50-50. The answer the government seems to be suggesting is that that's just going to all accrue to the lessee's favour. And the next is to limit the ground rent to be capitalised at the rate of 0.1% of the freehold value. Now that is broadly stated both within the Law Commission paper and some of the government pronouncements as constituting an onerous ground rent. Now there's no kind of legal or statutory definition of what comprises an onerous ground rent, but there is a case called Millard Investments in Cadogan, where the tribunal took the view and introduced the vernacular that a ground rent that's 0.1% of the freehold vacant possession value of the property is an onerous ground rent. And that's actually been adopted by quite a lot of building societies. So they're thinking of capping it. So what that means is, how do you look prospectively to the ground rent income that's going to rise over the term of the lease, and you're applying your discount rate to get the present day value of the future income streams. You're going to be capping the future income streams at that 0.1% level. And if this option is going to be taken forward by the government, and this is part of the second step, the first step is actually a relatively small step, given that it's just the prospective abolishment of ground rents moving forward, but that's going to be, one would anticipate, a relatively straightforward piece of legislation. Binding all of these proposals up into something that's going to comprise a statute is going to be an immensely complicated procedure. But if that option of the 0.1% cap was taken up, it would mean that leaseholders with onerous ground rents could buy out their ground rent as part of the lease extension claim at a greatly reduced cost. And the second set of proposals, and again, I have to say, on this slide and the previous slide is the entirety of the proposals. It really was a statement of intent in its most nebulous form, is that there would be an ability to buy out ground rent without extending the lease. And that was a recognition that, for some at least, the ability to retain the lease structure such that your landlord might be doing repairs or part of a much broader leasehold mechanism was something that was actually beneficial, and equally it would affect the cost if you're simply buying out the ground rent rather than thinking about the second limit, the valuation element, which is the deferment value to the freehold possession value. Now, so far as buying out ground rent is concerned, there are far more questions that there are answers at the moment. You know, what characteristics does the lease have to qualify? The Law Commission have been suggested that you could only do it if the remaining term of the lease is over 250 years. I mean, at the moment, it really is as comprehensive as you can see on the slide in front of you. But the kind of end position is fundamentally this is bad news for landlords and ground rent investors. Lots of questions for what I mean, prime amongst which is actually what is the definition of ground rent, because there's no legal definition, which property should it apply, and you know, all of these questions just beg the overarching question of what is the developer going to do to get around it. And you know, it's significant that in Arnold and Britain, which you know, is the case that we all often refer back to for the interpretation of contracts, the actual facts of those cases involved a service charge that was at £90 and rising at 10% per annum. And it's that may well be a mechanism which will come into the future to provide income streams without falling foul of legislation. Moving then relatively quickly on to estate rent charges. Rent charges is defined in the Rent Charges Act 1977 as any annual or periodic sum charged or issuing out of land. And the way that the vast majority of practitioners end up dealing with estate rent charges is when you've got mixed use estates, some of which are lessees, some of which are freehold, and you've got common amenity areas, and the estate rent charge is the mechanism by which the freeholders can be compelled to contribute to the cost of those common areas. And it's conventionally broken down into what's described as a service charge rent charge, which is the one that legislation is particularly aimed at and that we deal most frequently. And then you get a covenant supporting rent charge, which is rather more rare, but is a means of ensuring a compliance with a covenant and a transfer. Now, the reason why rent charges caught the legislative eye is that freeholders have nothing like the rights to challenge that lessees have in respect of service charge. So that's the first point. Lessees can go to the tribunal for service charges. There is no such regime for freeholders who are subject to estate rent charges, which fundamentally operate in the same form and mechanism. And the second is that Section 21 of the Law of Property Act 1925 incorporates some incredibly draconian remedies so far as non-compliance with payment is concerned. And the case of Roberts and Lawton is a great illustration of how it is that estate rent charges caught the legislative eye, because under Section 121, subsection 3, if you've got non-payment of an estate rent charge, the rent owner, which is the person to whom the money is to be expended, and will normally be a management company who are going to be keeping up the common areas and maintaining landscaped areas, if it's non-paid for 40 days, has got the right to enter into possession of the charged land and take the income until the rent and arrears are paid, together with all costs and expenses. Section 121(4) has an even more curious section, which provides that the rent owner, for non-payment of an estate rent charge, can grant a lease of the charged land to trustees, who are then, as a consequence of that lease, are going to try and raise enough rent and arrears to enable the rent charge to be paid. Now, this second limb took place in Roberts and Lawton, and the rent at charge arrears in that case were between £6 and £15. So we're talking absolute peanuts. And the rent owner granted leases of these freehold properties, residential freehold properties, to trustees, and inevitably the sums were then paid. But the difficulty was twofold. One, there was no mechanism to compel the trustees to surrender the lease. The lease has just remained in extancy, notwithstanding that the arrears had been paid. But also, two, the presence of those leases meant the properties were impossible to sell. And what would happen is this management company would then enter into negotiations with the owner of the land subject to the rent charge, who, having paid off their £6 or £15, what have you, was then faced with an administration charge of something like £650 for the surrender of the lease. And that was ultimately how the management company was feathering its own nest. And for self-evident reasons, that's caused a degree of legislative concern. So the two sets of reforms, and I'm going to deal with them again very briefly because they're nothing more than statements of intent at this stage. But the first set of reform is ultimately going to be changing the draconian remedies for the non-payment of rent charges. So we're getting rid and or ameliorating the effects of the ability to take possession on the part of the rent owner and or grant leases to third party. October 2020, the government came out with a statement of intent that it to all intents and purposes, is really to draw an equivalence between what lessees can do so far as service charges are concerned and what freeholders should be doing in the context of rent charges. And then in June 2019, the government took it a stage further and said, not only are we going to get rid of, insofar as we can post-consultation, the consequences of non-payment, and not only are we going to try and draw an equivalence with the abilities that lessees have to challenge service charges in the FTT, but we're also thinking about introducing a right to manage for residential freeholders, which presumably would have the same effect as right to manage for the lessees, which would be to take the management functions away from that third-party rent owner and enable them to ultimately use that as a mechanism to control the costs that they would otherwise be liable to pay. Now that brings me to an end of my segment, and I'm going to invite Justin to take the lead.
Right, I'll come back on. So far, Kim and Rupert, while you've been speaking, the Crown has made its all the way, as in the physical Crown, has made its way all to the front of Parliament. And apparently Her Majesty has just sat down. I have to say, watching someone live blog the Queen's speech is a slightly weird experience. Right, for the last 10-15 minutes or so then, I want to flag up something that's happening in Wales in the first part of next year. And it's important for two reasons. One, obviously Wales does have to be taken into account. Many of your practices involve property in Wales. Many of you will act for mortgage lenders and LPA receivers, for example, who have property interests in Wales. Secondly, these reforms are massive, and it doesn't take a genius to realise that if they go well, there'll be interest to copy the same things across into England. So what is happening in Wales in the first part of next year? Well, quite simply, Renting Homes Wales comes into force. It is a complete overhaul of residential landlord and tenant law in Wales. It's 15 years in the making, and it's intended to be a complete and self-contained code for all residential property, what we would think of as tenancies and licenses law, all in one place. The scale of the undertaking is enormous. It, for example, ends the lease license distinction. The Assured Shorthold Tenancy will be gone in Wales. And it's going to affect, as I said, just about everyone who has any kind of interest in Wales, landlords, tenants, mortgage lenders and LPA receivers being the obvious ones. In terms of the background, this too has its genesis in a Law Commission report. Back in 2006, the Law Commission published the Renting Homes report, in which they came up with three broad conclusions about how housing law presently operates. And the first is they said it was simply too complicated. I've got there a quote from the Parry and Harding case from 1925. If you thought it was bad in 1925, I can assure you it's significantly worse now. At least in 1925, no one had to worry about the gas safety regulations and how those impact on your ability to evict your tenant. But there's a fundamental theme that runs through lots of judgments on housing law and runs through, I would suggest, all sensible housing law policy, which is when you're dealing with something as fundamental as the basis upon which you live in your home, the law should be simple and the law should be accessible, and the law presently is neither of those things. Second thing, said the Law Commission, is that we've got too fixated on the nature of the landlord and how that impacts upon the rights of the tenant. And they said that shouldn't really matter. The nature and status of your landlord shouldn't be the key thing for determining what rights you have. And then the third point, and I think this is probably the single most important, is they said there needed to be a culture change as to how you think about housing law. You shouldn't think of it as an aspect of property. You shouldn't think of it as an aspect of the regulation of a landlord and tenant relationship. You should think about it in consumer protection terms. And part of that means, as we'll see, it has more than this, but part of that means the consumer should be able to go to one document, look and find in that document all of their rights as an occupier of residential accommodation. We shouldn't have to be resorting to implied terms as to the covenant for quiet enjoyment, or implied terms as to the nature of tenant-like user. you need to treat this much more like consumer protection law rather than landlord and tenant law, was the Law Commission's proposal. And so what they did is they proposed abolishing all the existing forms of tenancy. At the time, I think there were 28. I think there are presently 35 different forms of residential tenancy that can be granted. And they said, look, there should only really be two kinds of tenancy. There should be the secure contract and the standard contract. And in terms of what that would mean for people, they said the secure contract should be modelled upon Housing Act 1985 secure tenancies, and the standard contract should be modelled on the Housing Act 1988 Assured Shorthold Tenancy. And in principle, any kind of landlord should be able to grant any kind of tenancy. There should be prescribed terms that apply regardless of what the parties intend. So this is the implied terms equivalent thereof. And there should be scope for personalisation and personalised discussions and negotiations, but modifications from the prescribed terms should only be possible if they benefit the contract holder. So it's an element, again, of that consumer protection approach. The more powerful party, the landlord, doesn't get to propose the terms of tenancy. Parliament proposes them as a minimum standard, and if you want to give greater rights to the tenant, you can. In the same way that consumer protection legislation gives you a certain period of time to return a defective kettle, but many suppliers give you longer. That should be the same approach with something as more important than kettles. It should be the approach with housing, said the Law Commission. It wasn't just a stylistic shift. They also wanted some fairly significant changes structurally. So they wanted sanctions, both criminal and civil, on landlords who didn't provide for written tenancy agreements. And in terms of just how broad this was, they also wanted to overturn the rule in Hammersmith and Fulham and Monk. So this is the rule, as you know, that effectively makes it impossible to get one joint tenant off a tenancy agreement simply by having that one joint tenant serve notice to quit. You have to end the whole tenancy and then re-grant. And they said, no, this is dull. This isn't how modern relationships work. You should be able to add or remove a tenant through consent or through court process if needs be. That is an issue that hasn't gone away. There was an attempt to get the rule in Hammersmith and Monk overturned, which failed 7-0 in an absolute kicking for the tenant, represented by me in Sims and Decorum in the Supreme Court. And as you might have seen in the Domestic Abuse Act, that's just gone through Parliament and just got royal assent, there was an attempt again to overturn Hammersmith and Monk, at least in the domestic abuse context, which was defeated by the government, albeit they promised a consultation on possible reforms to the area. Not content with coming up with all these good ideas, the Law Commission also produced an entire draft bill, and the Westminster government did nothing with it, absolutely nothing. A 3-year project that the Law Commission spent a lot of time and money on, and the government didn't reject it, they just didn't bother engaging with it at all. So nothing really happened until 2012. The Government of Wales Act 2006 increased the Welsh Government's powers, and the Welsh Government, one of the first things they did with those new powers is they asked the Law Commission to look at renting homes again and look at how you could apply in a Welsh context, given that it was now within the scope of the Welsh Parliament to legislate on this point. So in 2012, they asked the Law Commission to update renting homes to reflect any developments in law or policy that had happened since 2006. And in 2013, the Law Commission produced an updated report. And that quote there from the Law Commission report, that's actually approving something that a commentator wrote in the 1980s, but that very much sums up the approach of the updated report. The purpose is not to regulate dealing with property, but to regulate accommodation. It's not about investments, it's about the place where people live. And if you approach it in those terms, as about the place where people live, rather than about the regulation of an investment, that inevitably means you need to think very strongly about security of tenure. Because if it's about where you live, you shouldn't be turned out of it except for very good cause. If it's about where you live, that should also mean that there are certain minimum standards in relation to conditions and in relation to other substantive rights, e.g. subletting or assignment, which we just think people should have because they're needed to enjoy their home, not because, as presently is the law, because of happenstantial development based upon the nature of the landlord. The last sentence really sums it all up. It shouldn't be about abstract considerations of the balance of responsibilities applicable to lettings. It's about a real world assessment of what people need in order to enable them to live in rented accommodation. As you might imagine, I might be able to tell from my tone of voice, I very much agree with these proposals. And so, having updated the report, the Welsh Government and the Law Commission then produced what became the Renting Homes Wales Act of 2018. And this is what I want to run you through in the next 10 minutes as to the key points of it, because it's very, very different to how housing law works in England. And the current announcement is this is going to be enforced in the first part of next year. So you've got about a year to get your head around this. There won't be any licenses and tenancies anymore. There will just be something called the occupation contract, which is the contract under which you rent your home. There will be two main types of occupation contract. It's not quite as simple as only two, because they've created special bespoke ones for some kinds of supported housing and such like. But basically, there are going to be two kinds of tenancy. See, I've got the old language still. Two types of occupation contract. The secure occupation contract, which is expected to be offered by community landlords, and the standard occupation contract, which is expected to be offered by private landlords. And a private landlord is simply anyone who isn't a community landlord. And a community landlord is, in very simple terms, what you would currently think of as a social landlord, albeit it's slightly broader than the current definition of social landlord, because for any of you who really follow the regulation of this, you will know that fully mutual housing co-ops pose a problem for the definition of social landlord, which they seek to solve with their community landlord definition. But there's nothing actually to stop a private landlord offering a secure occupation contract. And that's the first thing I think to flag up. Any of you who do act for, in particular, lenders or LPA receivers in Wales, this is going to be quite important, because if you've got a landlord whose property is subject to a mortgage and he grants a secure occupation contract, then evicting someone from a secure occupation contract is going to be very, very hard. So if you're acting for mortgage companies, whereas presently you generally prohibit any subletting other than on an AST for a term of not more than 6 months, that isn't going to make any sense in Wales after the beginning of next year, because there won't be any ASTs. They're only going to be secure or standard contracts. So anybody who acts for mortgage lenders, if they're doing any lending in Wales, needs to start, it seems to me, future-proofing their agreements now to reflect what the law in Wales will be in the future, because you don't want to be in a position where you're trotting out prohibitions on granting ASTs, and the landlord, the borrower, can safely say, it's all right, I haven't granted an AST, I've granted a secure occupation contract, because you haven't prohibited that. I mean, that's going to be the first sort of area where I can see this problem arising. The second thing it does is there are prescribed model contracts with some relatively minor scope to vary them, again, to the benefit of the occupier. What is absolutely striking, though, is the sanctions that are provided for if you don't provide your model occupation contract. Sorry, if you don't provide a written copy of the model occupation contract. The landlord has to give you a written copy of your occupation contract. If he doesn't give you a copy of the occupation contract, then he's in violation of Section 35, and Section 87, I think it is, gives the tenant a right to compensation. Compensation is not less than 100% of the rent for the period of the breach. It looks to me like it will actually be more than 100% if it's a failure to give the written contract, because the way the penalty provision opens is it sets the penalty at 100%, and then there's a provision for uplifting it if certain things are met. So it looks to me that if you don't give the written contract, then you're going to be paying 100 and something % damages until you get round to doing so. Given that there are many landlords in England and Wales who cannot presently comply with the tenancy deposit regulations, and the tenancy deposit regulations are 18 years old and ultimately consist of
put the money in a special bank account, give the tenant a form, and do not steal the money, there are going to be plenty of people who fail to get this bit of the Renting Homes Wales right. And this is going to be very, very expensive if you get it wrong. And as I say in brackets, pity the poor LPA receiver who's going to have to grapple with all this. And as is always the way with LPA receivers, they never have all the relevant paperwork provided to them because they've ended up taking over a property where the borrower hasn't managed their finances properly. So the idea that they're also going to be able to prove they complied with their duty under Section 35 strikes me as unrealistic. So the damages are going to be potentially significant. There's also some quite extensive succession provisions that are worth talking about. There's going to be this new idea of a primary and secondary or reserve successor. And succession itself isn't that revolutionary an idea to the people in this call, because you're quite used to the idea of successions from joint to sole, or from husband to wife where one of them isn't a tenant, or from parent to child. The interesting bit in the Welsh one is they're going to create a new right for carers to succeed to tenancies. So non-family member carers. And I can see that being, particularly in the social sector, I can see that being an area that generates an awful lot of litigation. But it's not limited to social sector tenancies. It applies to both standard and secure occupation contracts. So rights for carers look like quite an interesting development. And the third broad thing it does is it changes the way that possession works. For claims by landlords, you're going to have only two different kinds of route. Well, it's not quite true. For claims by landlords under secure contracts, there are going to be two different kinds of way to seek possession. The second, which is called the estate management route, is pretty much what we're used to at the moment with the Schedule 2 Housing Act 88 grounds or the Rent Act cases. Prove a ground and prove reasonableness. There's a new route for possession, though, which is going to be if you break any term of the contract and you can prove it's reasonable to make a possession order. So you're going to see all those bits of the of what we currently think of as Schedule 2, i.e. Ground 10, the tenant is currently in breach of a term of the tenancy. That's going to come out and going to be replaced by this new breach of contract and possession route. Now, it's a slightly different way of doing what we already do, but it probably isn't going to be that difficult to get your head around. The really interesting bit is going to be standard contracts, because standard contracts, you're going to have the option of ground plus reasonableness or breach plus reasonableness, and you're also going to have the two equivalents to what you currently have as Section 21 or Ground 8. But note, you don't, therefore, have a Ground 8 equivalent for a secure contract. So housing associations who offer secure contracts are going to lose Ground 8 as a route for possession. Under a standard contract, their equivalent of the Section 21 procedure will continue to exist, but you have to give 6 months notice before you use the equivalent of Section 21. So the 6 months Section 21 route that's currently the law in Wales as a result of the coronavirus extensions will continue being the law after Renting Homes comes into force. Secondly, Ground 8, so mandatory possession where arrears are over a certain level, will continue to apply in Wales, albeit they call it something else now, but for standard contracts only, with one important addition, which is the new Ground 8 in Wales says that in addition to meeting the rent due when notice is served, rent due at date of hearing, the right to possession is, quote, subject to any available defence based on the contract holder's convention rights. But does the contract holder have any convention rights? Because MacDonald and MacDonald in the Supreme Court provides that there's no human rights defence to a private sector Section 21 claim. And the European Court upheld that in JFM in the UK. So are there any private sector convention rights available? Is the Welsh Government trying to say by this provision that it intends to overturn MacDonald and MacDonald? Is it that MacDonald and MacDonald doesn't apply because The Housing Act 88, as the judgment explains, was a project, was the result of a long and detailed consultation process all about revitalising the private sector, and part of the importance of that was the right to possession, whereas Housing Wales is not about revitalising the private sector. To the contrary, it's about improving the security of tenure and other occupation rights of people in the private sector. So does that mean that human rights defences are alive in Wales but not alive in England? If they're alive in Wales but not alive in England, whilst that's clearly intellectually conceivable, it's not very attractive to have a situation where two people with identical factual situations, one gets a human rights defence because they live in Cardiff and one doesn't because they live in Bristol. Is there a difficulty there in terms of discrimination against tenants in the rest of England? I'm not convinced there is, but someone will run the argument. But you can immediately see there is going to be a lot of scope for litigation on how Housing Wales will pan out. I'm going to wrap my little bit up there because I said I would rattle through this, and because you've all kindly listened patiently for 20 minutes or so when I said I'd only be 15. Kim, I know, has to dash off because you've got to go and do some work. The strange thing that people have to do during the day. But myself and Rupert are around if anybody's got anything they'd like to talk about. One question came in as Kim was doing her presentation, and I confess I answered it in the chat box. If anyone else has got any questions, do feel free to type something in there now. Rupert, if I can trouble you to turn your camera and microphone back on, so I know that you're there and you're not just ignoring me. Kim, are you definitely off?
I'm afraid so. I have to
all
go and join another meeting, but thank you very much everyone for attending, and if there are any questions, I'm sure you're in very good hands, so I'll
yeah. You're leaving us. Just, if you've got like friends going to put in some really mean questions now and just expose the two of us.
I'm going to put them in anonymously and then leave.
Right. Well, thank you very much. Thanks for your time on this. I'll just keep an eye on the question box, but I don't know what, if anything, will come in. You are all, I'm sure, desperate to dash off and watch the Queen's speech and see what there is going to be in terms of updated announcements about ground rent reform and law commission proposals. But I'll give it another 30 seconds or so. Let's just have a look at what we had in the Queen's speech so far. Yeah, so the Queen's speech is announcement of the new building safety regulator. So that's presumably going to be the building safety bill coming forward. What else?
We've got a question that's just come in, Justin. Is there any idea on the timing for the law? I think that's a reform.
Very hard to say, I think, is the answer. So law commission stuff, the government need to actually decide which bits they're going to accept. I mean, as Kim explained, they've done like fairly warm words at the moment, but they haven't said which bits they're going to accept. Then the law commission, assuming this works the way it normally does, the law commission is going to need to do a draft bill. I don't see that being less than a year's work on drafting that. So I would imagine the law commission stuff, if it's going to come forward, is probably 18 months, 2 years away at the earliest. Stuff Rupert was talking about, as I understand it, MHCLG was fairly advanced in its internal drafting of the ground rent abolition bill and some of the other technical changes around estate charges. I confess I wouldn't be surprised to see that in the current Queen's speech, which means you get it through Parliament this year, look to come into force April next year, maybe something like that.
Yeah, the prospective abolition, in the sense that new tenancies can't have ground rents greater than zero, I would expect to be in this Parliament. I think for the other changes, you know, what the Law Commission did was set out a series of options for the government to choose, which is why they didn't annex a draft bill. The government's given very warm words, but I don't think it's really come to a concluded view as to what it's going to elect to do. I mean, we've got these nice sound bites which say abolition of marriage value, but you know, no one's really actually thought through exactly how that's going to be made manifest. So as Justin says, I think those step 2 changes, so not prospective abolition of ground rent, I would have thought would be some way away, to be honest.
Yeah, they're going to be fairly technical, and they'll need quite a lot of destructive testing to make sure they work. I would have thought this isn't one where you want to legislate and get it wrong and have to come back in 18 months' time, because the mess that will cause is significant. We might know a bit more today at the end of the Queen's speech, but I think that must be right from Rupert, that the easy low-hanging fruit of there shall be no new ground rents, that's not very difficult to do. That should be relatively soon. There's a question about, in a rising property market, usually cheaper to extend or enfranchise today than it will be tomorrow. Should they wait? I mean, I've been asked this by a few people, and my view is always, well, it depends. If you've got 82 years left on your lease, I wouldn't be waiting in hope that the government is going to ride to the rescue and abolish marriage value and make it all easy for you in the time that's meaningful for your lease. If you've got 150 years left on your lease, you probably have got time to wait and see. I know that's a bit of a cop-out answer, but I think it largely depends upon what your current position is and whether you've got a need to move forward at the moment, or whether you are prepared to wait 18 months on the off chance that by then we'll have more of an idea. I don't know if you've been asked about this, Rupert. I mean, are you sort of saying, are you saying wait, or are you saying push ahead because the government may never do this anyway?
I'm broadly of the view that if the claim started in its currency, I would not really advise pulling the plug in the hope that something might happen in the near-term future, because I really don't think it will. I do think we're looking at a horizon of 4 or 5+ years, and ultimately, as we know, the moment your term starts falling beneath 90-80, you get difficulties of movability, you're going to get difficulties of sale. The hopeful listeners might think, well, actually, let's wait and see, but you shouldn't really be doing that. I think if you're at a term that's even remotely likely to have consequences in sale value as a consequence of time elapsing from now until the point at which you start it. So I'd keep going with those claims, certainly those that existed.
Do I think it's likely that the new provisions in Wales will impact on the availability of private rented sector accommodation? I don't really know the answer to that, is the honest answer, because I litigate about buildings for a living. I don't really understand how the market trends work. I mean, the house isn't going to go anywhere if the landlord decides to up and sell. The Welsh Government are fairly open about their intent, which is to professionalise the private rented sector in Wales. I don't think they'd be that bothered if small-scale landlords left and sold up into bigger portfolios. Look at the regulation in Part 1 of the 2014 Act in Wales, their landlord licensing scheme. They very, very much want to drive up standards, both in terms of the quality of the stock and the quality of landlordism. And if landlords sell into larger consolidated portfolios, I think the Welsh Government would regard that as a success. If they sell to new occupiers, I suspect the Welsh Government wouldn't be that concerned either. So I don't know is the answer, but I don't think the Welsh Government are that worried about it. Rupert, do you think there could be a human rights challenge by landlord to the proposal to eliminate marriage value?
No, not really. I think that would be, it would be a very difficult one to possibly justify. I mean, the government intervenes in the housing market the entire time, which has the effect of, changing rates of return. But if the actual basic statute can come through, in other words, it is a form of statutory approved appropriation, but there's part and parcel of the state's actual reservation of rights to manage its own assets and deprivation of personal belongings and livelihood. I mean, it's a bit of a stretch. So I'd be surprised, is the short answer. It would be an ambitious argument.
I mean, for our questioner who asks that, if you go on the Law Commission's website, they commissioned advice from a QC about this question, and they've published the advice. And the QC, much more expensively and at rather longer length, comes to exactly the same conclusion as Rupert, which is you have a massive margin of appreciation if you're the government about how you regulate the housing market. I mean, if you stole it off the landlord and forced them to give money to the tenant in compensation for the horrors of being forced to be a leaseholder, that might be a little bit extreme. But if you just say that in Parliament's view, the statutory balance is X, Parliament gets to make that choice. If you don't like it, vote for the Protect the Landlords party at the next election. A question what if you have a 60-year lease? Then the answer is you have a short lease, and it will be expensive. And it is likely to still be expensive, I would have thought, even after the Law Commission reforms. This is an interesting one. So Rupert, some of the big house builders have already implemented the zero ground rents rates, which indicates the market is happy to accept the proposals. Do you agree?
Well, if you think about the changes, the market changes that zero ground rent actually means, well, first, ground rent investors are going to be deprived of an asset in which they tend to place their money, so pension funds and the like. But it's an important source of return for house builders because they measure up their profit matrices when they're looking about development proposals, not just on the function of how much you're going to get for actually granting the lease, but also what you're going to get for conveying the freehold. So in terms, it's going to have wider effect. It's a disincentive for house builders, but as we all know, the government is not shy about introducing schemes to ensure that its very ambitious rates for building houses are sustained. So I wouldn't be remotely surprised if it's just counteracted by a form of state support for them that comes in the form of a different mechanism. But really, those are the two parties that are going to be substantively affected. It's going to be the ground investor and it's going to be the builder. Ultimately, the government will do what it takes to make sure the houses are being built. So I just wouldn't be surprised if it's just substituted for another source of income.
Just one final bit on the Queen's speech. I've got the text of it here. The ground rent abolition bill is in the Queen's speech. So, but it looks like it's only the ground rent abolition bit, as you predicted. They will leave all the more technical stuff for later on. So that will be in there. But at the moment, let's see if there's anything else. Which brings me to the last question. And what's the latest with the ban on leasehold houses? I don't know. I confess I'd assumed they do that at the same time as the ground rent restrictions one, because they've been lumped together in all the consultation papers. But do you know, Rupert? Is there anything more on that?
Not that I'm aware of is the short answer. I think it's a space, but I'm not aware of anything that's going to say anything determinative for that answer, I'm afraid.
No, I mean there isn't really any good reason to have a leasehold house anymore. But and my understanding is that in any event, the market largely responded with the number of new leasehold houses being created just going through the floor. So it may be that it's less of a problem at the moment because the market has seen the reaction and has stopped building leasehold houses, and the government will get around to banning it later. I'm going to wrap this up there, if that's all right with everyone. Thank you to Rupert and Kim for their time and their hard work in getting all this ready for you. Thank you to all of those of you who chose to join us today and to stay for the duration of this session. This will be up online later on today. You will get an email from Landmark Chambers, which will give you a link to the recording. And as part of that, you'll also have a link to our slides if you want them. Otherwise, I think it just remains to say thank you very much. And I sincerely hope we get a chance to see some of you in person in the not too distant future. Thanks a lot.
Thanks, everybody.